ask questions. It's not just this going on. Does anyone have any questions of Kate on this topic at the moment?
The only question I have is the transportation from the place of death to the place of burial. Is the person for it to be buried, can the owner of the cemetery transport the body, or does it have to be transported by a licensed funeral director or whatever?
But it says in number 3 that any bodies transported from the property for any reason prior to burial shall be transported in accordance with state law by a licensed provider of funeral services.
That states is transported from the property. What about to the property? What Delber's question was, from the place of death to the property.
So that one was pulled from, let's see, it was KSA 65, 17, 34, I believe. I printed off those statutes for you. All right, so 1750. You all want to read over that? Todd Luckman put that in.
I didn't see whether it was discussed for on the place of death.
Yeah, it's in the second sentence there. In the statute. The location of death should be transported only to a licensed funeral establishment.
I would probably recommend putting in KSA 65-1734 in the regulations there by that sentence.
1753.
1734. Or is it 53? It's 53. My apologies. It's 53.
Says that to be removed. But it should be transported only by a licensed funeral establishment. That is not in the regulation as written by the county commissioners, as I see it.
So we need to incorporate Kate's suggestion in subpart 3 of the proposed special use regulations. Just go back and read
Well, I think reference with the state law is all encompassing. And then by adding statute number 65-1753, we cite the specific state law to refer to.
So basically add part 3.
I have a couple of suggestions.
Please go ahead.
First of all, I'd suggest that instead of paragraph E, it would be paragraph R. adding into an existing paragraph is somewhat confusing. This would make it a new paragraph, the last paragraph in that section. Then on the second page, Roman numeral 7, says no burial site shall be located within 100 feet of water line, with 100 feet of a water line, sewer line, or similar. I believe that should be within rather than with. And then paragraph Roman numeral 3 would be suggested. There's already a semicolon. They just add KSA 65-1753, another semicolon, and then you can. Yeah, I'm moving that we amend pursuant to that statement.
Okay, I also have some modifications.
Okay. Want to add those to my motion?
But do you mind, well, actually, let me ask if there's a second first. Might have some additional modifications before we do consider before the motion we made. So it's up to the board if you want to second that or just leave that for now and then do a full motion here in a little bit. That's up to you. Anyone wants to go ahead and second that?
Let's do that. Second, I second the motion. Or what is it?
Okay, I'm suggesting we don't second it, but that's up to you. If you want to second it,
Well,
that's going to complicate things later.
no, it'll make things simpler because if they don't like any part of that one, then it shouldn't be considered. We can consider this, have that behind us, and then go to the next motion.
That's true. That's what you do. I'm sorry, would you mind reading? Motion after discussion.
I move at present Article 7 be amended by replacing paragraph E in the first line with paragraph R, rather than adding it to language that doesn't really have anything to do with what this is talking about. Then paragraph Roman numeral 7, where the word is with 100 feet of water line, be amended to within 100 feet of the water line. And it's paragraph Roman numeral 3, following the semicolon, KSA 65-1753, semicolon.
Now,
And you seconded that?
yeah, then second that. That's good.
We can call for discussion, but to be honest with everyone, we're getting things out of order. According to our procedures, we need to have a public hearing. We have not had a public hearing for anyone to comment on this before we start making motions.
They need to know what it means before they have comment on it. If we're going to amend it, they need to know what the amendments are before they comment.
Right, but once the motion, if the motion passes, then the board has already taken the action without allowing the public to comment on this.
Public gives some comment on the totality. They need to know what we're going to put in this before they comment on it.
Right, but if the board has already taken the action to approve something before the public's been.
All we're doing is amending what we're going to submit to the public. We're not deciding whether or not we're going to pass this. The motion is simply to amend.
In previous actions, when they make a change, that's been the final motion. There's not been any, okay, let's do this and then
in the first, we're gonna go yes or no on this, and you have some modifications, as I understand it. So you'll make another motion to make your modifications. Now the public will know what they need to comment about.
I understand that. Okay. There's a motion on the floor.
It's been seconded.
It's been seconded, exactly. So, is there any additional discussion by the board on that motion? Okay, all in favor?
Aye.
I'm going to oppose, because I don't think the comment is correct. So 5 yes, 1 opposed, motion carries. Let's go back to our agenda that we're supposed to be following. I need to open the public hearing so that the public can comment. Again, the proposal is to modify the county rules on establishing family cemetery or burial plot on a private piece of property that's not in a what might be called a public cemetery, like the Soldier Cemetery, the Dealey Cemetery, and one of those established cemeteries, which we have many around the county. Is there anyone here that wants to speak in favor of making any changes to this part of our zoning rules? And then after the people that have spoken in favor of making some changes have spoken, then we'll go to people that are opposed to any specific changes or any changes to the rules in general. So if you could state your name for the record, please.
Ann Harper.
Anna?
And I have a couple of issues that I see here. Number one, the bodies must be further related by blood, marriage, or adoption. I can think of several scenarios where you might be a close family friend and you might wish to be buried on that land, or you used to live there and then somebody else bought it and they offered to let you be buried there. I don't think you should have to be there to be buried there. And then my other issue is, number 4, that after the first burial is made, no one can be buried anywhere else on the property. I don't think that that's necessarily feasible because it could be that a spouse, one wanted to be buried on this hill and one wanted to be buried on that hill. So those are the issues I see.
Anyone else? Okay. Anyone have other concerns or is opposed to changes in this particular section of the regulations?
Jeanette Branson, it's really just clear because that anybody transported from the property, because if somebody dies on the property, I understand that you have to have a determination of death and how they died, so they would have to go to a coroner's office, or would a coroner come out? I'm confused as far as transporting the body to or from the property. Is it just from the property, so if somebody died on the property? Like, how did the body get to the property in the first place? So does Kansas State, I'm sure if you just referred it to Kansas State law, it would give you what you needed to do, but that's kind of confusing to me because it's just transporting a body from the property. So does that mean somebody passed away on the property? Or they've already been transported there for burial? I kind of find it a little bit confusing.
One with logic, I'm sorry, can you state your name for the record? I didn't catch it.
Jeanette Branson.
Thank you, Ms. Branson. And obviously those scenarios are quite possible. People can pass away, on their property or obviously anywhere else. So either one of those situations could occur. Do we have any comments?
I would say refer to 65-1753. It's transportation of the body.
it's not clear, but if the body died on the property, you either have to have a physician's certificate of the cause of death, or would have to be transported somewhere for that to be determined, so you could comply with paragraph 2.
Of the state statute.
No, but they have to determine the death did not result from contagious, infectious, or because it was injury.
Could you pull up that statute again, as well as, and also the proposed rules from the county?
Let's see, there's the statute.
Right. So that way you can enlarge that, I'm sure people can read that, you can come over here. People read that, those who want to read it, can you read that? Go ahead and, Kate, go ahead and pull back, go back to the proposed section B. So next point was section 2, that did not result from a contagious, infectious, or other communicable disease. Any other questions, comments, concerns?
Yeah, I got one. Caleb Martin, and on E number 2 there, it says as long as it did not result from contagious, infectious, or communicable disease. So if my loved one dies of influenza A or say COVID, does that exempt them? I mean, I have a problem with that. If you die of the flu, it's considered a contagious or infectious communicable disease. I mean, I don't agree with that, right? Is that, you know, if it's, as long as it's not, is that, I guess, can we verify if you die? I mean, it seems rather vague if you die of any communicable disease or whatnot, when it's saying you can't be buried there. But if it's the flu, I mean, because people die of the flu all the time, are they saying that they can't then be buried on the family plot? Is that not true? Can we clear that up, take that out? I mean, is that in there to comply with some other statute, state law?
That's in there to comply with, that's in there to comply with state statute,
Okay.
but you still have to make an application for permission. And then that could be decided whether or not that was a communicable disease.
Okay.
Otherwise, the other option, of course, one of the public, unquote, communities. Yes, name please.
Jay Sims. Why are we writing laws for in the county that are already covered by the state? Doesn't that add confusion? Rather than comply with the state, you comply with that, why do we have to write the same law at 2 levels of government?
State rules are always going to apply because we're a unit as a county, we're a unit of the state of Kansas.
Right, so doesn't that make that obsolete? If you're trying to write the same thing they wrote, why you write it again?
The counties and local governments have the option to add to state rules. And that's what we're trying to do, is clarify for Jackson County what, if any, additional rules we
this particular thing is not covered in the state. That,
I would say,
It is not.
okay.
as far as the local level. Any other, yes?
Yeah, Jeanette Branson, you're referring to the state in the article that you had up there, and you have anybody's transported from the property for any reason, transported according to state law by a licensed provider of funeral services. But in this, article, it doesn't talk about who is transporting the body, it tells you where you can transport it to. So unless there's another, and I don't know if you call it an article or whatever, that dictates who is legally allowed to transport, I don't see in here that it designates anybody. It's telling you where you're allowed to have that body transported to. Because I'm all about state law, but if you're gonna refer to it in state law, then what you're writing in your regulations it shouldn't contradict or not follow along with the state law.
It looks like that law is more concerned with where it's going, not who's transporting it.
Well, I think we answered that. The only reason you'd have to remove it from the place of death, it's on the property, would be to determine what the cause of death is. In most instances, there'd be a doctor. If there wasn't a doctor there, it'd probably have to be performed.
Well, that does say it has to be transported by a licensed funeral
Right.
state. So it addresses that.
Where does it say it in this one that you referenced?
Shall be transported, I mean, this is.
The way I'm reading that, and correct me if I'm mistaken here, that state statute on the screen only does not address the question that she's asking about who can transport it. It says where they can transport it, but not who. And I think there's, in our proposed rules of Jackson County, we are not proposing any sort of restrictions on who can transport.
Well,
That's my,
Paragraph 3 says by a licensed provider of funeral services. It does say right.
right, that,
That's what
The law does not say that. That's something that Jackson County is adding to.
yes.
I would say just edit what Jackson County is trying to do, just to follow the state law instead of adding an additional sentence in there that's not within what the state law is saying. Because the state law doesn't talk about, in this instance, doesn't talk about who can transport the body. It only says where it has to go. And then Jackson County is trying to say who can transport the body. So their law, what the law says, and what Jackson County are trying to do are going in two different directions. They're not the same.
Section 3 is state law. Jackson County is complying with state law.
Section 3 says who can transport the body, but the state law says where the body has to be transported to, but it does not dictate who transports the body.
Well, that's not in that statute.
State statute, at least my reading of the state statute, does not refer to who can transport.
Sure it does something.
Yeah.
And even if it doesn't, Jackson County can go above state law, you just can't go
We could make it simple and just say transportation must be in accordance with Kansas State statute.
In section 3, it says, shall be transported in accordance with state law by a licensed provider of fuel services. That is section 3, use regulation. That's the Jackson County statement right here.
Any other questions? Okay.
That addresses who, right there. Because the state law must, somewhere in the state law must say,
Move on.
Do you have anything else to add, Bill? Okay. Okay, I'm going to go ahead and close the public hearings now. The change that I want to suggest the planning commission consider is related to identifying the specific location of the burial plot. Proposed rules allow up to one quarter of an acre. And real burial sites shall be located within 100 feet of a water line, sewer line, or similar easement. I have a concern about when a property is, would be sold at some point by the current owners, being able to identify the specific location within that quarter acre, which is actually a fairly sizable piece of ground. It could be basically anywhere within that property's boundaries. It could be up against county road. It could be towards the back of the property, away from the county road. Obviously, water utilities are usually nearest near the road for a number of reasons. So I would actually suggest that everyone on the board can pull out your letter from the county to Gerald Green dated August 21st, 2023. Over the key. Remember this letter was here. I would suggest adding the first three sentences. Do you have that?
The first three sentences of that.
Of section 2. Kate, do you have that by chance?
Yeah, all graves are to be marked with a headstone or ground plaque. The minimum container is a wood box. No vault is required. 2 copies of maps must be always maintained, one by the family and one by the custodian.
I wanted to ask the board to discuss item 3 in the letter. Concerning plants must exclude grazing animals. I at least suggest adding number 2 to our proposed rules.
So my comments would be, aren't we adding things that other people might not want to comply with? If I'm going to sell my property to someone, and they want to know where it is, all they have to do is hire someone, designate that. If I don't care, somebody farms over it, that's my business, it's my property. Why should you make it more difficult for me to sell my property by having things on it that other people might not want?
So if we're to survey a property, wouldn't they want to know that there's.
Well, yeah, you can survey.
Right,
But if you didn't care what they did with it, they wouldn't need to know. They wanted to plant a garden there, they could plant a garden. For I'm saying, I think putting the additions on it would make it more cumbersome for a landowner.
I understand, but, I think we need to, look at, certain things that could happen down the road.
So like what?
Well, if, to me, there's still a chance that somebody, a specific location within that quarter acre, could somehow be lost on.
What would be in the title report? It would be in the title report.
Yes, it should be. This is also, I would think it would also be helpful to have a physical marker on the surface. So
And all the prospective buyer would have to ask is if they want to do that.
True, but they may or may not. There's still a question in my mind about the prospective owner or a future family member that plot gets passed down to a relative and then a generation later or whatever. The new relative that occupies that property might not remember, okay, here's where this relative is buried. So having some sort of physical marker on the surface would be more permanent. To me, would be a good thing to have, because that's up to the board to.
I think that's up to the man.
John, if I may add, I also agree with that. That was one of my main concerns, that if a landowner chooses to do this cemetery plot, that then becomes sacred ground, and it is removed from any other future uses, such as you're saying, farming over or whatever. That is one of the stipulations that you would say, if you're going to do that and you're going to accept the responsibility that this piece of ground will now be sacred or whatever, that it may devalue that piece of property in the future for a future sale, but that's what you're accepting by doing this. And I would agree, I would like to have markers or something so that down the road, somebody doesn't go in and try to dig dig a water line or whatever, and all of a sudden hit a body. That wouldn't be very good to have.
I might add that was the same, number 5 is the one that I was concerned about, no markers. I think there ought to be some type of markers.
And I think that's answered by, in that letter that we have, that adding that paragraph, or that statement, that graves would be marked with a headstone or ground plaque. I think would be important.
There's another question that kind of goes along with that. In the proposed county rules, there's no depth requirement. I'm not certain exactly what the minimum standards are for public cemeteries. I'm just thinking back to personally dug graves that I've seen, maybe 6 is close to what the standard cemetery depth is. Really don't know. That would be another topic that we would not want to talk about. Try to avoid now, that's the water lines can be whatever depth, an area, of course, minimum 3 because it's trees on 3 feet. think theoretically, we could take out that first sentence in section 5. And instead, substitute we keep that next sentence where we just believe that's replace that with section 2 underneath that. And then that's the ordinance to do that.
Could you just make it, that all burials have to be at the same standards that a public cemetery would have?
I'd suggest we find out. I don't know what the depth is. I think we should be specific about integrated burial. I don't know. So you're suggesting that we substitute the first sentence of paragraph 2 of the paragraph 3, third letter for Roman numeral 5? All graves are to be marked with a headstone or ground plaque.
Yes, whether the board wants to add the next two sentences about minimum container open box and the walls or not, it's up to the board. But yes, the minimum have that first sentence under item 2 is the letter to the closed in section 5. Substitute for the substitute for both of those sentences, correct?
Yes. Well, we do it in one sentence. All markers not required on the site column. That one sentence will replace that sentence. And then you want to add 6 feet, I think is normal. Body should be very, the depth of not less than 6 feet.
That'd be my suggestion.
I guess my question is I thought state law required that you have a vault. You can't go out to the funeral home and not have a vault. I mean, you have to. You don't have a choice. Correct?
Well, I've had a president very good thoughts.
They have a vault.
Dr. Matty Mosher, and I don't think he has one.
I think that this might be the reason for that, that someone doesn't want to have to pay for the vault and things like that, and they own the land, they don't have to buy the burial plot. They can go ahead and bury it.
Well, just throwing that out.
Yeah.
Well, I think they checked all the statutes. I don't know what the statute was. And that may be the chute, and that may be the cemetery.
That may be.
A question with regard to this letter that was sent out, was that approved and all of these stipulations abided by in that? Because the proposal that we're putting forward is less than that, the regulations that were required in that letter. Because they were required to put a containment fence, and we're not requiring that in this. So, do we need to go by what was established in this precedence and make that the county's recommendation? I mean, if you require this one person to do that, but then the new regulation doesn't have those same requirements.
This also says how far it needs to be from the property.
No, he has not said exception. And we're in the process of making the precedent.
And that's what I think that we should almost go to those recommendations that were included in that letter of containing the fence and, you know, the setbacks off of the property lines.
To part of, where your point is, I know this was a year ago, dated letter. Do you recall, obviously each property owner, I would think, would have a certain part of their property that they want to establish this private burial plot. Part of, this is one of your case response to this. Do you recall if, I'm assuming only part of those restrictions were specific to that landowner's request, so they set back for that landowner?
But it's in the letter.
It might be a little bit different for a different landowner.
It's in the letter.
Simply because that's where that landowner wanted to.
It's in the letter. It's a special use permit.
Right.
It's specific to that piece of property.
Yes, but those distances might vary based on what a particular landowner might request.
Right.
At least that's.
I mean, I understand that.
Size is what was requested and the location.
By that landowner, yes. I don't know if that answers the question.
Yeah.
Okay, so we have several things on the floor. One is to include a marking requirement, which is under the letter section 2. Whether or not we want to include a fence.
There hasn't been a motion to that.
Right, yeah, those would be the three things if someone wants to make a motion of some kind to modify the appropriate sections of the proposed section.
I make a motion that we change 5 to all grades are to be marked for the headstone or.
I second that motion.
Seconded to modify section 5 to say all graves to be marked by headstone or round plaque. Markers by headstone or round plaque. Is that correct?
Yes.
Any additional discussion on that? Okay, all in favor?
Aye.
Aye. 6 in favor, motion carries. Does the board want to add anything regarding that or fencing?
Well, I would move that we add section 5. The body is to be buried to a depth of not less than 6 feet.
I'll second that.
That sounds a little bit excessive, Dick. If you're not required to provide a vault, if you only having to, if you're going to let them use the box,
What do you have a depth that you would prefer?
I would suggest that we have a minimum depth from the ground level down to the top of the, whatever the burying item is, whatever they're in, whatever they're encased in. Like, say, 25 or 30 inches below. Which means that they may be able to do maybe a 4-foot depth, for example, as opposed to a 6 foot. in the wintertime, it's pretty hard to get down 6 foot sometimes. I don't know if you've ever, like, been around when it's had ditches raised, and 6 foot is a bit of a shock, that is a bit of a shock.
Well, I thought we were trying to do our best to comply with the state law, so just assume that's appropriate.
How deep do they normally bury a water line?
3 feet by state law in this,
3 feet?
but that's because that's below the frost line. And I believe that the depth of burying bodies, I don't have any basis for this, I believe it just was based on years ago with predators and scent and other things of getting it far enough below. I don't know what the state statute. I mean, I think in this instance that we shouldn't go above or, you know, beyond what the requirements of a public cemetery would be.
I agree with
But
that.
I also think that we need to have a certain requirement so that it's not 2 foot deep
Yeah,
and a coyote.
I agree with that. But 6 foot is required probably if you're gonna use something like a bulb, but you're not allowing them to use a minimum of, like a wooden box. I don't see any need to require a 6 foot depth if you're just gonna use a wooden box. That's all I'm saying.
I think you wanted a couple of feet below where somebody might dig a water line.
I'm sorry.
I wouldn't want somebody to hit it if they're digging a water line, I'd put a couple of feet below it, or at least 5 feet.
And you could say that the minimum depth is to the base of the hole. Instead of saying minimum depth to the top of the box, but that way it's I mean, if it's a 2 foot tall box, then your minimum depth, or your box is at 4 feet below ground surface. But your minimum depth to the base of the hole is 6 feet. I would say that that's what most cemeteries are. They dig down to 6 feet, place the box in the hole, and then so they're 3 to 4 feet below the ground surface.
Motion has been seconded to bodies to be buried, are to be buried to a depth of at least, no less than 6 feet. Correct?
That is correct.
I'll second that.
It's a big second.
Okay,
Thank you. Is there any additional discussion? Okay, all in favor?
Aye.
Any other proposed changes to this section of the zoning rules?
I'm a little concerned about, again, how far this is from the property line. I guess this would be each right case, every time this comes up, they'll have to approve the county commissioners will approve the exact location. So the county commissioners, every time this comes up, have to be approved how far it is from the property line.
So this would be a special use,
Yeah,
it would go before you all
okay.
each time.
Maybe
Somebody
we don't need to
wants.
address that.
Huh?
So we don't really need to address that.
Each location is gonna be in a different location, so that's gonna be a case by case.
Right, so there will be, what case is saying, yeah, there will be, the family member would come to this board and say, okay, we want to establish this on our property, here's what, you know, make it look a little map, so here's what we want to do on this.
Yeah, and the public would have a chance to comment.
Right.
I'm just making sure.
Yeah.
I know somebody put a cemetery right on my property line, I want something to say.
One right across the property line, I would think people would want to know, next door, or across the road.
I have a little bit of a question about the transfer, non-transferable between property owners, and is there, if someone establishes this, and then 20 years later, 30 years later, the family sells the land and the new owner comes in, is there any type of a burden with this permit for the new owner to have to maintain or keep? I mean, we required them to, I mean, I don't know, I know it says it's non-transferable, which means that the new owner can't bury someone there without without applying for a new permit. But is there any burden to maintain the
Well,
current?
the seller can have to establish it. If I own the property, and I want to sell it to you, but I want to maintain it, I have to make that condition known. And then you either accept that or say, no, I'm not buying the property, but I got to keep that up.
Or if you want an easement to access it.
I mean, but we're not requiring anything as such.
Well, I don't think we should. We can't have the burden on the respective lot. If the landlord can then sell, that'd be our help.
Good question. Yes. I can see also two possibilities of that depends on the sellers. Consider established conditions, and not just that first seller, but all the sellers down there. And there are ways, of course, to make with that original family member's place basically permanent conditions. Right, exactly, on that.
Yeah.
Public order, piece of ground. Possible modifications to this section. Nine. Okay, that was the final thing on our agenda for tonight, so I will entertain a motion to adjourn.
But you've got to give them a chance to make comments on modification. That's why I wanted to do all of it before we put public comment.
No problem with allowing it. So, does anyone have any comments on this matter?
Yes.
Please go ahead. Nancy, I know you've given your name before, but good morning.
Hannah Harper, as to all of your things about you have to have markers because nobody's gonna know what it is. Section 4 designates by map and plat, meets and bounds description, now location. So you don't have to have a marker to designate the exact location.
That's a legal requirement
Yes.
on paper that's filed with the county.
Yes.
It says nothing about something that's visible to
Yes.
the family.
I understand that, but I'm saying that as far as you're concerned, that if somebody else thought it, they didn't know where it is, it's fine. So they would know where it is. And I don't think that it's necessary to put a marker down. Not everybody wants their break marked. Us who wants it designated that way. And the whole point of being able to have it through their own means is to do it how you want. So I think that that's unnecessary. I also want to know, you asked us for public comment and then didn't address any of the people's comments. You just moved on. Why did you bother having public comments? You weren't gonna. I'm just confused.
He opened it up for discussion.
Yes, you did, but you addressed the KS 65-175-3 didn't need to be there, and then you listened and then moved on to what you didn't do anything.
Well, we tried to, I tried to, ask Kate, okay, would you pull that section out?
Yes.
So we could try to figure out, what the answer to your question and everyone else's questions were at those particular moments.
Yes.
What are the answers that we have tonight?
Well, I also addressed the issues with section 1 and section 4. You didn't. I understand that you guys are in charge of doing this, but it would have been nice to have that at least acknowledged in your conversation.
And I think you're concerned about adding friends. That opens it up into anybody that wants to be married, anybody, if they want to marry, then they can marry. So you make it wide open. And I don't think the commission wants to. I think it was a limit.
What is the purpose of making sure that everybody buried in that graveyard is related by blood? What the
It's because it's a family plot,
Yeah,
by
but I mean,
definition.
I might not be legally related to somebody, but they still may be somebody that I consider my family. Like, there are relationships that aren't always established by legal
And
precedent.
definitely, they're not family.
But I mean, you're not really protecting anyone from, I'm just curious, what does it protect someone from if I have my aunt who's not really my aunt, she's just been someone who's come to every family function for the last 20 years. She wants to be buried in the family plot, we've always treated her like a family member. Nobody ever adopted her. How is anyone hurt by me being able to bury someone who's not legally related to me or blood related to me?
Because and he's also trying to minimize the number of people buried in a family plot.
Why?
And if you open it up, because then you could have 40 bodies out.
And a quarter acre though?
Yeah, I was gonna say, there's gonna be space, I mean,
All the family plots I've seen going up and down the highway don't have 40 bodies there.
Most people don't want that, though. The people who
Right.
want that should be allowed to.
I think you're assuming intent, and you shouldn't do that. You're assuming other people's intent before there's anything there.
But the county, on the other hand, can't assume people will do the proper things.
So
Unless we
we're
have
all guilty
guidelines.
until proven innocent, then, right?
I'm sorry.
We're all guilty of doing something wrong before we've been given the chance. You just said we can't assume that we're gonna do the proper thing, but you're assuming that we're gonna do the improper thing. So that's you assuming
County's
guilt.
position is a family plot should be a family plot.
And what defines family? Adoption's not
We're not
legally
necessarily
defined.
going to open a regular cemetery. If you want, I'm sorry,
A regular cemetery implies you get paid to be put there.
regular cemetery, you can bury anybody you want.
Yes.
That's what the county has not wanted.
Yeah, so this isn't a.
We've been asked to provide something that isn't now in the law. And that is a family cemetery. And that the county is going to do. That was the request.
But family cemeteries are addressed in state law, right? And you say family plots are addressed in state law already, so you're not allowing us to do something, you're hampering it by interfering with the state law that's already there.
That's what's before the board.
Well, that's what we're doing right now. You're telling us no.
We vote if they agree with you, and we'll have to go back to square one.
So if all of us in the room say we don't want this, will you still vote how you want to, or will you listen to us?
Okay, what I think is right. Not how I look, what I think is correct.
So then why do you bother having a public hearing if you're not gonna listen to us?
Because they've already made some modifications.
Correct by whose standards, yours or ours? The people that you're representing. Your standards or the people that you represent standards?
Represents people.
Like when the people right here that care about it showed up and we're telling you what we feel, and you're telling us you don't care how we feel, it's about what you think's right. So you're not representing us, you're representing yourself.
Anybody in the board wants to make a motion? They're free to do that, and no motion has been made. So apparently the board does not agree. I call it the question. Let's vote.
I'd like to point out that cemetery, crematory, and mausoleums are also special use under Article 7. So that would probably be public cemeteries, allowing more people.
So if I wanted to bury a close family friend that I could just completely ignore, family, not do a family cemetery, just do apply for special permit deed and do a family cemetery my way on the. Is that right?
Which that cemetery would be a state regulated cemetery.
So we have less regulations than me.
Probably not.
I mean, if this, so if we do E, we don't have to follow the state guidelines if we do E.
We have not.
Is that right?
Can't imagine this.
There's Mr. Chairman, I move to adjourn.
A second.
Yes, we move and second to adjourn. Any discussion?
Very fascist.
All in favor?
As long as people want to talk, I don't think we should. It's not, I mean, within reason.